Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. This is Josh Sharfstein. Today, we turn to a decision from a U.S. District Court in Texas striking down a provision of the Affordable Care Act. Joe Palmore is a former assistant to the Solicitor General at the U.S. Department of Justice and current co-chair of the Appellate and Supreme Court Practice Group at the law firm Morrison Foerster. We talk about this case, called Braidwood Management, Inc. versus Becerra, including the potential consequences for health and what comes next. Let's listen. Joe Palmore, welcome to Public Health on Call. It's great to have you to talk about this Affordable Care Act decision that just came out of a district court in Texas.
Very happy to be here.
Before we jump to the details of this decision, could you help me set the context? I know you've been working on Affordable Care Act litigation for a long time. I mean, the law passed 13 years ago, and it's still in the courts.
There's been a lot of litigation about the Affordable Care Act over the years. The first lawsuits were literally filed within minutes of President Obama signing it. And there have been several that were frontal attacks on the entire statute and where the plaintiffs were seeking to invalidate the entire statute. In recent years, there have been other cases like this one that don't pose the same threat to the overall statute, but attack various components of it.
So this particular lawsuit, for example, doesn't put at risk the ability for people to get health insurance under the Affordable Care Act at all. Would that be fair to say?
Yes. So it's not like the King versus Burwell case that would have overturned the premium subsidies, for instance, that help people afford insurance coverage. This one goes to the scope of that coverage and what services might be provided under it.
And that's no small matter, because what we're talking about are prevention services that the Affordable Care Act promised people would be available to them at no charge.
That's right. The preventive services requirements in the Affordable Care Act are incredibly important. They're incredibly popular also. Basically, they require coverage of certain specified preventive medical services at no cost. Tens or hundreds of millions of people have now access to these coverages, these services at no cost because of this part of the Affordable Care Act.
And we're talking about mammography, for example, for breast cancer, or medications that people take to avoid HIV infection, or vaccinations.
Right. All of the above and more. Not all of that is actually going to be at issue in the decision that we're going to talk about. But yes, those are the kinds of services that are covered by health insurance now at no cost to beneficiaries because of this part of the Affordable Care Act.
And just to be clear, this requirement to cover preventive services, it applies when people get insurance through the Affordable Care Act through exchanges, but it also applies more broadly. Is that right?
Yes, it applies to all private insurance. It also applies to self-insured plans. And a lot of people work at companies that finance their own health coverage. And it also applies to those companies.
Could you just explain under the law how this preventive health services benefit works under the Affordable Care Act?
Right. So Congress did something here that it often does, which it establishes a general policy and leaves the details to experts. So rather than listing out all the preventive services that Congress thought should be covered, it said the services will be covered at no cost if they are recommended by certain expert bodies. Now, like a lot of things about the Affordable Care Act, it's kind of complicated because there are a number of different expert bodies for different areas. But they said that these expert bodies will make recommendations, and they had already made some at the time the Affordable Care Act was enacted in 2010. And on a going forward basis, they can make additional recommendations. And when these expert bodies make those recommendations about what preventive services are important, then those services will become mandatory, that those services be covered under the statute at no cost.
So, for example, there's one expert body for immunizations. Is that right?
Right. There's one for immunizations. There's one for women's health. And there are a variety of these expert bodies that are named in the statute.
This case is about one of those, the U.S. Preventive Health Services Task Force.
Right. It was initially about all of them, actually, but the plaintiff's challenge to several failed in this court, but succeeded with respect to the U.S. Preventive Services Task Force.
So that is a group of experts that makes recommendations on a wide number of preventive services. Under the law, if they recommended it, then it would have to be covered. And I know one of those services, for example, is the ability to get medicines to prevent HIV. And the argument, I guess, in the court is can't rely on that group. Could you explain what this court decision and this court case is about?
Right. The court ruled for the plaintiffs on two different grounds. We can talk about them in turn. The first one was a claim that they brought under the Appointments Clause to the U.S. Constitution. And that's part of the Constitution that requires that important government officials that it calls principal officers be nominated by the president and confirmed by the Senate. So I'm sure, your listeners have seen confirmation hearings for the Attorney General or the Secretary of HHS or the head of FDA. Those are principal officers, and they have to go through a certain process before they can exercise governmental authority. What the district court here held was that the members of the Preventive Services Task Force had been given so much authority under the Affordable Care Act that they were principal officers, yet they are not appointed by the president and confirmed by the Senate. So the court held that the actions they had taken under the Affordable Care Act or efforts by the government to implement or enforce the recommendations they had made were invalid for that reason.
Got it. And what was the second basis for the argument?
The second basis was kind of a religious liberty claim brought under a statute called the Religious Freedom Restoration Act, or RFRA. And that's a federal statute that says that if federal law substantially burdens religious exercise, the government must show that it has a compelling interest in enacting and enforcing the law, and that the law is really truly necessary to meet that interest. And so these plaintiffs have religious objections to certain of the preventive services that health insurance plans are required to cover under the Affordable Care Act. Most principally the PrEP medication, which you would know better than me, but as I understand it, is a very important medication for preventing the spread of HIV. And they have a religious objection to procuring or providing insurance plans that cover that medication.
And just as a quick aside, there was previous litigation about contraception, which initially was covered under the Affordable Care Act. How did that settle out?
Well, in the Supreme Court's Hobby Lobby decision, the court held that under the Religious Freedom Restoration Act, that certain employers did have an ability to basically exempt the plans that they provided from the otherwise universal requirement that contraception be covered or certain contraceptives be covered. This is the first case that kind of extends that logic beyond contraceptions and extends it to, in this case, the PrEP medication.
So those were the claims. What did the judge decide in the last couple of weeks?
Well, there were a series of decisions. There was a first decision on some of these issues in September, and then there was a new decision to kind of close out the case and provide remedies at the end of March. And between the two decisions, the court ruled for the plaintiffs on their Appointments Clause argument only with respect to the Preventive Services Task Force. They had made a similar argument with respect to some of the other expert bodies. The court rejected those arguments on the ground that the Secretary of HHS, who is a principal officer, in effect had the final authority over those bodies. So there was not an Appointments Clause problem. But the court did find an Appointments Clause problem with respect to the Preventive Services Task Force recommendations, and in a sense invalidated all rules or efforts to implement any of the recommendations made by that task force since 2010. And that's an important distinction. The court did not vacate all the rules with respect to recommendations that had been made before the Affordable Care Act was enacted, on the theory that Congress had, in a sense, itself adopted those because those existed at the time the statute was enacted. But anything coming afterwards, including, for instance, coverage for PrEP, was invalidated nationwide.
So now I'm understanding which services might be affected. It's those that this particular task force made or recommended after the date of passage of the Affordable Care Act. And I'm seeing a list here from Kaiser Family Foundation that says that includes medication to reduce the risk of breast cancer, screening for lung cancer, colorectal screening for adults age 45 to 49, hepatitis C virus screening, as well as services that relate to pregnancy and HIV testing and this HIV prevention.
Yes, that's my understanding too. It's a subset of the preventive services that have been covered under the Affordable Care Act, but an important subset. The other part of the ruling was the Religious Freedom Restoration Act claim, and the court there held that certain of these plaintiffs had prevailed on that claim because they had a religious objection. The court held that providing coverage, for instance, if an employer had a religious objection to coverage of PrEP, that being required to provide coverage for that did substantially burden the owner of that business's religious exercise, and that while the government did have a compelling interest in preventing the spread of HIV, that this coverage mandate was not necessary, in a sense, to further that interest, that there are other ways the government could do it. And so that employer with the religious objection could get an exemption basically from that part of the coverage requirement.
So a pretty big win for the plaintiffs at this particular court, and huge implications because it just doesn't affect the plaintiffs. It potentially could affect a whole country, and its access to preventive services under the law. This judge, if I'm not mistaken, also ruled in favor of striking down the entire Affordable Care Act in an earlier case. Is that right?
That's right. This judge, who sits in Fort Worth, did issue a decision invalidating the entire Affordable Care Act about 4 or 5 years ago. That decision went all the way up to the U.S. Supreme Court and was eventually reversed. But this is a judge that a lot of plaintiffs who want to challenge the Affordable Care Act or challenge parts of it do file in that court. He's had a lot of these decisions.
So the news reports have suggested that there may be an appeal from the Justice Department. Do you think that's likely? And what do you think the Justice Department's going to argue?
It's already happened. The government did very quickly file a notice of appeal to the Fifth Circuit Court of Appeals, which is the court that reviews decisions of the district court in Texas. And we don't know yet whether they will also seek an emergency stay to pause the district court's decision while the appellate proceedings go on, but there will definitely be an appeal. I think you're likely to see arguments made by the Department of Justice in the Fifth Circuit, similar to the ones that they made in the district court that were not successful there. I think on the appointments clause, they will argue that this is really just an advisory body, the Preventive Services Task Force. They are volunteers. They're not paid. They work part-time. They make recommendations. That the government will argue that they don't exercise the kind of governmental authority that would make them principal officers under the appointments clause. And on the Religious Freedom Restoration Act claim, the government is likely to make several arguments there. One, they will argue that there actually is not a substantial burden on free exercise, that simply providing coverage that other people will use doesn't burden the religious exercise, for instance, an employer, and certainly doesn't burden exercise of individuals who may have plans covering all kinds of services that they don't use or want to use. That doesn't burden their own religious exercise. I think that's an argument we're likely to see from the government. And the government will also say that even if it is a substantial burden, that they can pass the RFRA test in a sense, because there is a compelling interest in preventing the spread of HIV and that this actually is a necessary means of meeting that interest, because there's a lot of studies that show that copays, not to mention lack of coverage altogether, is a serious impediment to access to these kinds of medicines. So those are the kinds of arguments I think we're likely to see advanced by the government in the Fifth Circuit, and ultimately potentially in the Supreme Court, where this case could go. The plaintiffs could also appeal. They didn't win everything they wanted in this case, so both sides could actually appeal. And so, for instance, recommendations made by some of the other expert bodies could continue to be at risk in this litigation.
Wow. So this could actually get worse for coverage of preventive health services.
Potentially, if the plaintiffs appeal and if some of their broader arguments or different arguments were successful in the higher courts, then yes, it could end up being even more sweeping.
Would it be wrong for me to just have the assumption this will probably find its way to the Supreme Court, given that so many other Affordable Care Act cases have found their way there?
Well, it would not be wrong for you to assume that it will find its way there, in the sense of someone will undoubtedly seek the Supreme Court review. Whoever loses in the Fifth Circuit will undoubtedly ask the Supreme Court to step in and decide the case. Whether the court will do that or not is a separate question. They're very picky about what cases they take, but you're right, they have taken a lot of Affordable Care Act cases over the years. So it's certainly within the realm of possibility that this one could end up there.
Let's just talk about the practical implications. So this basically means for insurance companies, they're not forced by the law to provide certain coverages, such as for the preventive medicines for HIV. But it doesn't force them to not cover it. And insurance companies immediately said there would be no change to their coverage. What do you think is going to be the practical impact as this works its way through the courts?
It's a great question. I mean, I think as I mentioned before, I think it's probably unlikely there'll be an immediate impact, just because these companies don't turn on a dime in their, coverage decisions and their year-long contracts and things like that. Even long term, I think there's just a question out there about what insurers might do. You're exactly right that this ruling, even if it remains in place, just says they don't have to do this. It doesn't say that they can't. Coverage of these services is quite popular, and some companies may be reluctant to take them away.
Right. And let me just add, it's not that expensive. In fact, for PrEP medicine, it almost certainly saves money, because you're avoiding very expensive diagnosis like HIV.
Yeah, I think that's true for a lot of these preventive services. That's in some ways the point of them, that they prevent serious disease, and so they can actually save the insurance companies money. So they may have a business reason to continue providing these services, but time will tell what would end up happening if this ruling remains in place.
If the ruling does remain in place, and if there were a plan or a goal to essentially overturn it, that would require action by Congress, I suppose. What could Congress do in that eventuality to make sure that preventive services are covered?
Well, on the appointments clause side of the case, there would be probably a relatively easy fix for a statutory amendment, where Congress could give the Secretary of HHS, for instance, the ultimate authority to bless the recommendations of the Preventive Services Task Force. That was the basis for the court's rejection of the appointments clause challenge with respect to the other expert bodies. The court said, well, the Secretary of HHS has ratified, the court said, these decisions, so in effect made them his own. And the Secretary of HHS is obviously a principal officer. He's nominated by the president and confirmed by the Senate. But the court said that the secretary lacked that authority with respect to the recommendations of the Preventive Services Task Force. So Congress it wouldn't even necessarily even be a sentence. It could be a phrase they could add saying subject to the final decision of the Secretary of HHS or something like that. So it's an easy fix. But of course, all legislation about the Affordable Care Act is controversial and polarizing. So whether Congress would actually do that is a separate question. On the Religious Freedom Restoration Act side of the case, it's, I guess, less clear what the fix there would be. But that one has less sweeping impact, because it only applies to the set of plaintiffs who have this particular religious objection to coverage.
Got it. Well, Joe Palmore, thank you so much for joining me on Public Health on Call. It's great to see you, and you've given us a lot to think about.
Thanks for having me. It was great to have the discussion.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmond. Audio production by J.B. Arbogast, Holly Cardinale, Philip Porter, Spencer Greer, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Fernandez and Shian Briscoe. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.